Hello, everybody, and welcome to another episode of the Trusted Trustee podcast. And as usual, I'm joined by the lovely Tracey Besters for this session. Hi, Tracey, how are you going?
Good morning, Darin. I'm very well, thank you. And yourself?
Yeah, not too bad, not too bad. I was hoping that this spring weather would really start to take, but it's not, because everybody who knows me knows I don't like the cold, so I'm really keen for summer to get going, but it just seems to be stopping this stop-start thing. It's not really very conducive, I don't think, anyway.
That's why you haven't moved to Darin yet, Darin.
No, Southern Highlands, way too cold for me. My blood's obviously too thin for that, for that thing. I know I'm a bit of a wimp. You can call me.
You're allowed to be. You're allowed to be.
And of course, this podcast is brought to you by Superfund Property Valuations, ATO compliance in a click. If your SMSF accountant or auditor is on your back for a property valuation, just order an affordable report from the experts with ease using the details on your screen now. And as I always say, property valuations and asset valuations in particular, very, very, very hot topic with the ATO. So yeah, absolutely great service there, and can't emphasize enough the importance of that area. And again, of course, with the $3 million cap potentially coming in, even more emphasis is going to go on to that. Well, anyway, last time, if people were watching this podcast or listening to this podcast last time around, we spoke about reversionary pensions. That's kind of been an extended theme of what we've done in the first sort of few podcasts that we've done. So whenever the subject of reversionary pensions comes up, you've always got a discussion about binding death benefit nominations as well, because you're talking about the whole estate planning picture, I suppose, and what is suitable for different individuals in different circumstances. They're often referred to as BDBNs. Of course, we love our acronyms. Certainly never enough, or too much is never enough as far as acronyms go in the superannuation area. So today we are going to talk about binding death benefit nominations. And Tracey, maybe you can start by stepping us through what they are and what role do they play, because I think there's always a little bit of confusion about, why do I need one of these? Doesn't my will sort of handle this situation? And that's a lot of the time where the conversation starts.
Yeah, absolutely, Darin. And yes, we love our little acronyms, don't we? Our TLAs, our 3-letter acronyms, but BDBN happens to be a 4-letter acronym. So just to confuse the matters more, but binding death benefit nominations are hugely important in the superannuation space, and particularly in the SMSF space. And I guess to start that conversation, Darin, and to talk about death benefits and estate planning within the concepts of the self-managed super fund, I think the most important thing is that the documentation is crucial, and it's all about documentation. So we can have a binding death benefit nomination, which means that is a death benefit nomination that is written up, if you like, by the member of the SMSF, and it's binding on the trustee. So by virtue of the word binding, death benefit nomination means that it's binding on the trustee should the nomination be valid in the first place. And we'll come back to validity of these documents in a little bit. But if we have a death benefit nomination that isn't binding or doesn't meet the requirements of it to be binding, then that is a death benefit nomination. It's the wishes of the member given those instructions to the trustee, but not necessarily binding on the trustee. So do you need a binding death benefit nomination, or do you not need a binding death benefit nomination? Well, it depends, doesn't it? And we've got that wording really quick. So it depends on your circumstances. And, if you have a normal family, and I joke about normal families because I'm yet to meet too many of them. But if you have a normal family, you've got husband and wife sitting in the self-managed super funds. It's not a blended family. So first marriage, the wishes are that the money goes to each other. whether that's in pension or whether that's in accumulation, and then the money will go either out to the estate or to the children, then you may not need a binding death benefit nomination, because a binding death benefit nomination is going to put those hurdles in place to prevent any legal challenges to your wishes. So if you don't have the potential of legal challenges, then you might not need to have that binding death benefit nomination. So what we seem to find in practice is that we have these these self-managed super fund setups, and a lot of these SMSF setups and establishments, Darin, come with this template of a binding death benefit nomination. And so it's kind of like you've got this whole folder of documents and you're just filling every page. Well, you might not need to fill in every page, you might not need that binding death benefit nomination. So I don't think that you should always have a binding death benefit nomination. I think it really needs to come into light with your, and into the whole mix of your estate planning and how complicated or how straightforward your affairs might be. Yeah. So I think it's not an absolute must. There are some commentators that, think you should just have a binding death benefit nomination. I don't think that you necessarily should. I just think it needs to be one of the tools that you can use in order to get your benefits where you want them.
Well, as anything in the SMSF world, it's always going to be dependent upon your individual circumstances. Right. It's very difficult in this area of superannuation to issue blanket strategies to say that you must have this, because there is no blanket thing. And I suppose that is the beauty of SMSS, is that they're an individual vehicle that you can tailor to your own circumstances. So very good point there. But you also raise documentation, and documentation is always an important thing, no matter what strategy or what action you put in place with your self-managed super fund. And I just wanted to, as usual, we'll link it to another topic here, and that is the trust deed, because the trust deed's interaction with a binding death benefit nomination can actually reinforce the power of it, but it can also actually erode the value of putting it together. And I'm specifically thinking of trustees who say that, well, the fund just has to adhere to the superannuation legislation, because that small thing can get you in a lot of trouble, can't it, Tracey?
Yeah, that's right, Darin. And, I think that it comes, we've said it depends really early on in this podcast, and now we're going to talk about the trustee. So we're ticking all the boxes today, aren't we?
We really are.
Look, the trust deed is the governing rules of the fund, Darin, and it's kind of like the game plan of the fund, and so you have to adhere to the rules of the fund, otherwise you're in breach. So, for example, if your trustee said you must adhere to the superannuation laws, and the superannuation laws required X, Y, and Z, and you didn't do X, Y, and Z, then you have an invalid documentation. You have an inconsistency between the execution of a document versus what the governing rules require. In a superannuation environment, a binding death benefit nomination needed to be, redone every 3 years. It was only valid for 3 years. Yes. Well, a self-managed super fund, that doesn't apply. That three-year rule doesn't apply for a binding death benefit nomination in a self-managed super fund. But if your trustee said that it needs to be renewed every 3 years and you're at year 4, then you no longer have a valid binding death benefit nomination. And I always liken this stuff to an insurance policy. You take out an insurance policy and you want that policy to pay out when you need the money the most, right? So if you've got this binding death benefit nomination, Darin, and it's invalid, then at the time that you actually want it to be valid, then, what's the purpose of the documentation in the first place? It's the same conversation we have with enduring power of attorneys and having that control in the fund. So it's got to be valid, and the document has to be consistent with the trust, obviously with the superannuation laws, but on top of that, it has to be consistent with the governing rules and with the requirements in the trust deed. So you can't just blanketly fill out a document and just think that everything's going to be okay. You have to actually go back to the trust deed and see what the rules of the trust deed are. And as we know, every trust deed is different. Every documentation provider has slightly different terminology in their trust deed. So we've got to make sure we have a look at those.
Well, they do. And it's a really important point to make. I know we're concentrating on the trust deed now, but very often document providers or maybe even advisors might think that something that comes along with what is considered catch-all provisions, which is basically general items in the trust deed, which potentially means that, oh, don't worry about it, Darin. If we put this clause in, then if there's a change, you won't have to worry about anything because it will incorporate any legislative or regulatory changes in that. So it's an easy thing to not even know about. But the consciousness of, well, what does that actually mean? I mean, what we're referring to, there was a recent case called Hill versus Zuda, and that was testing whether or not a binding death benefit nomination did expire for SMSF trustees or after a 3-year period. And basically it was that no, because there is an exemption for SMSS. But if your trust deed says that you have to adhere to the legislation and regulation, then yeah, it does expire within 3 years.
Yeah.
And how would you know that? I mean, and I'm not suggesting every trustee has to be a legal expert as to what their trust deed says. So how would you know that? But it is something to have on the radar. Very, very important.
Yeah, and remember, Darin, that when we become trustees of our self-managed super fund, we actually sign the trustee responsibility declaration with the ATO, or it's not called that, the trustee declaration with the ATO, and the first paragraph of that trustee declaration says that we are responsible. So yes, we can have all of our advisors, but we are still responsible for what happens within our self-managed super fund. So we do need to rely upon our advisors, because we're not suggesting that every trustee needs to go and get a legal degree. Certainly, I'm not interested in going and getting a legal degree. I spent enough time in this place, but we're not suggesting that. But you still have to understand what your particular rules are, because otherwise, how do you know if you're operating within them, or how do you know if they are consistent with what you want? So, and there's been lots of situations where. And lots of cases over the years, Darin, about the validity of trustees, binding death benefit nominations. And this is the area that gets attacked. So if you have a situation where you absolutely want to make sure that your superannuation benefits go to that superannuation dependent that you want, and you don't want it to be challenged in any way, shape or form, so you want to use this binding death benefit nomination, make sure it's done consistent with the trust deed. I had a conversation many, many years ago, Darin, with a guy who said, why can't we just have a 5-page trust deed? Why can't we just have a cover page, a signature page, a title page, and then 2 pages that basically say, it might have been 4 pages actually, 2 pages, the 1 to 2 pages that basically say, the superannuation fund can do everything that superannuation laws allow. And I'm like, well, that would be easy from a documentation perspective, but where in the superannuation laws does it tell you how to commence a pension?
Yeah.
Where in the superannuation laws does it tell you how to get the voting right in meetings? It doesn't tell us. It doesn't go. The superannuation laws, whilst they are extensive, they don't give us the day-to-day practical how to do things. So if we don't know how to start a pension, we don't know how to do a binding death benefit nomination, we don't know how to do member voting or take records of meetings or any of those sorts of things, how do we know that we're right? And if we've got this broad range in the superannuation laws, then we may be right, we may not be right, but who knows? And we're going to have all of these court challenges. So we've got to be more specific. And that's why the trust deeds are so lengthy, because they need to cover off a whole lot of things, one of those being binding death benefit nominations.
Yeah, I mean, that's so right. And it's a point that can't be emphasized enough. And it applies really across the board. I mean, again, we go off on a tangent, but if you apply a similar philosophy to the investment strategy, you can't have, I can invest in this in my portfolio and the allocation can be between 0 and 100%. And we know that is a valid condition some investment strategies like to have documented, but it's meaningless because it's kind of like the broader you make it, and certainly in this case, the less meaningful it is. But in this case, it just opens the way to legal challenges. And speaking of legal challenges, and while we're on the subject of documentation, some of the conditions are a little bit strange too, that you have to watch out for. I mean, we mentioned the legislation and regulation in superannuation law just applies to this fund, but there can be little quirks, can't there, Tracey? As in, I know this sounds a little bit silly, as in if you do a binding death benefit nomination, you have to submit it and show it to the trustees, and they
Yeah,
have to acknowledge that they've seen it. A
yeah,
condition which is really just adds an additional hurdle, which you don't really need. Some even say, don't they, that if you want to do a BDBN, you have to do it on a specific particular form.
yes, that's
And if
right.
it's not completed on that specified form, it's invalid. So
Exactly, Darin.
there's a whole range of rabbit holes that you can go down as far as documentation goes,
Yeah.
and just the importance to get it right is incredible, really.
Absolutely. And this is why you don't take it lightly. You don't just say, oh, yeah, I've got a BDBN, no problem, because you might not have a valid BDBN. Yes, you might have a binding death benefit nomination, but it may not be valid. And coming back to the point that I was making before around the validity of a document, and when do you want that validity tested? You really want to know that it's valid when you're signing it, right? You don't
Yeah,
want to wait until you've gone and your poor family is trying to deal with some challenge
yeah,
by an aggrieved party who didn't get money that they thought that they might get, and therefore they're trying to challenge the validity of the document. Because if the document's valid, then it's binding on the trustee. If the
yeah,
document is found to be invalid in accordance with the rules of the trust deed, or the form that it's on, or whatever it is, whatever those little idiosyncrasies are, then it's not binding on the trustee, and therefore the trustee can pay out those death benefits in accordance with what the trustee thinks, or think the best decisions for the trustee. So yes, you've got to acknowledge it. So remember that member hat and that trustee hat. Well, you're kind of saying to yourself, here's my binding death benefit nomination. Yes, thank you very much. I acknowledge your binding death benefit nomination, but you've got to document this stuff. It can't be, you've got to have the contemporaneous documentation to be able to rely upon in the event that this gets challenged. And, there's a famous case, the Munro case, of a binding death benefit nomination. Now, Mr. Munro was a solicitor, if you remember that particular case. And he was a solicitor and he did a binding death benefit nomination, and he wanted to pay out his benefits to his estate. Well, he wrote the words, my estate, or something like that on the binding death benefit nomination. But the fine print of his particular binding death benefit nomination form that came with his trust deed required him to write my legal personal representative. So just, obviously his intent was to pay to the estate, but he didn't write the specific words that were required in his situation, in his governing rules being his trust deed and the form that was submitted with that trust deed. He didn't honour that. So, there's little things that we just have to make sure that we get right. Otherwise, we might as well rip that binding death benefit nomination up and throw it out the window, because it's just not going to be valid.
yeah,
So
100%. Sorry.
so we've just got to get it right, and we've got to make sure. So it's not just a throwaway process. It's not like we sign our trust deed, we sign our member application forms, we sign our appointment forms, we sign our ATO trustee declaration. Oh, and let's just sign this binding death benefit nomination while we're at it. We should not do that at all. We absolutely shouldn't do that at all. The whole estate planning process in the super fund we need to give it due consideration, and the time and the energy and the importance that it needs. So
Yeah, 100%, Tracey. And just to add on, you mentioned it's not a throwaway thing. Well, certainly it's not a throwaway as far as these documents go. I'm not suggesting anybody throws away their SMSF documents, but can you actually place your hands on them at any given time? Because unless you keep a history, and I'm not just talking about the binding death benefit nomination, I'm also talking about, again, the trust deed, that if any changes are made along the way and there is a legal challenge and you have to go back and recreate, how do you describe it, an audit trail or a history of what the fund has done, if you can't find that documentation, then potentially things that you thought are in place are no longer applicable. And that is a very, very painful and hard lesson to learn.
Yeah, absolutely, Darin. And, these things often come come to light in a blended family situation. We often, we've got spouse from the children from the first marriage, second spouse, etc. This is kind of where we see a lot of these kind of argy-bargy things. And you're absolutely right. If we can't connect so let's say we've done a buying death benefit nomination, right? And we did that 10 years ago, and we now can't find the trustee that we had 10 years ago. Well, how do we prove that that binding death benefit nomination from 10 years ago is still valid?
Yeah.
How do we know that? Because we don't have that trustee. So the documentation requirements and keeping those documents is really crucial. And I think now that we've got the ability to electronically store documentation, I think it makes it a whole lot easier rather than carting around a massive box. But, there's a lot of things that still require wet signatures, and we need to keep the actual physical paper copy of those things. Just make sure that we've got multiple copies given to our advisors, so that they have copies of these documents as well and can help us piece it back together. Otherwise, we'll be visiting the lawyers to be able to help us out with where this documentation is.
Yeah. Good point. And a nice little segue there. You mentioned the blended family. So if we move away from documentation just for a little bit and get back onto BDBN, how powerful are they, and how flexible are they when you're talking about wishes when you've got a blended family? Say, for example, it doesn't have to be a blended family, but many instances are, if I pass away, I want my super benefits to go to my spouse. And if my spouse is no longer there to be a beneficiary either, then I want it to go to my kids. And of course, the blended family makes it a little bit difficult because sometimes the current spouse is not the original spouse, obviously.
Yeah.
And then the kids are not necessarily with the current spouse. And that's where a little bit of friction comes in. So how flexible are these things, and how much of that detail can you build into a binding death benefit nomination?
Yeah, so they can be really flexible, Darin. And I think that's the great thing, self-managed super fund, choice and control. And that's why people set them up mostly, that's the two answers that we get. Well, I can do a better job than anyone else is the third one. But whether that's true or not, we won't go there. And we're not going to get into that argument. But choice and control. So a binding death benefit nomination can be very flexible. Now, in any estate planning decision and in any conversation around paying out death benefits, we still have to take into consideration the underlying superannuation and taxation laws. So who are my superannuation dependents? So can I actually pay a super death benefit to this person? So they have to be a superannuation dependent, number one. If you don't have any superannuation dependents, then you can rely on the kind of catch-all phrases, if you like. And then, are they a tax dependent? Are we going to be able to get taxable component money to those people tax-free? So we've still got to come back to that. But given all of that in mind, so we've got our superannuation dependents, we know who those people are, a binding death benefit nomination can be really, really powerful. And then there's this whole conversation between if I've got a reversionary pension, just to take us back to what we we're talking about in the last podcast, if I've got a reversionary pension and I've nominated my reversionary pensioner or beneficiary in that documentation, what if I've then got a binding death benefit nomination and they're inconsistent? Which one will rank higher than the other? Now, that depends as well on the trust deed. So it generally speaking, we would say that a reversionary pension will rank higher than the binding death benefit nomination for what's sitting in the retirement phase account, generally speaking. However, your trust deed might say something different. Your trust deed might actually rank the binding death benefit nomination higher than the reversionary pension. So you've really got to go back to the words of the trust deed and see whether the trust deed actually has that wording in there. If the trust deed is silent, then it's going to unfortunately come down to a judge's interpretation if it ever got to that stage. So we want the trustee to actually have some authority with this. So it's important to have something in the trust deed. I think personally, I like to have some certainty over the outcome where possible, because we've got all of this money sitting in the SMSF space and we want some certainty over what's going to happen. So I like to have more certainty myself because then I know what I'm dealing with. So you can be flexible. You can pay money to your spouse, money to your children. You could say you want it in the binding death benefit nomination. You could say, I want a death benefit pension to go to this person, my spouse. And then I want this particular dollar amount of lump sum to go to my child. And I want then this lump sum to go to this child. Like, you can actually be quite specific and quite flexible in the binding death benefit nomination, provided the binding death benefit nomination itself is valid.
Do you see many instances where people have both a BDB and a reversionary pension, and potentially those two strategies are at loggerheads with one another?
Yeah, I have, Darin. I don't see it as much anymore because we try and educate people and clients around the importance of this. But years ago, I had a situation where the self-managed super fund, 2 members, husband and wife, the wife had a substantially higher balance than the husband because that came from money that she inherited, and then she made contributions to the super fund.
Mm-hmm.
And she was quite specific that she didn't want that money to go to her husband if he was in a new relationship. Mm-hmm. So she was quite happy for him to have a lifetime pension, if you like, but no lump sum. The lump sum was to go to her children. So the legal advice that we sought at the time was that we had specific wording in the pension documentation. So remember, the pension is a contract between the member and the trustee of the fund, and in that documentation, it literally had my husband can get X amount of dollars CPI indexed for his lifetime, but on his death, then all of the proceeds, lump sum, are to go to my children. And that was the legal, the legal advice we received was that that was okay. Obviously, the trustee needed to be in accordance with that, etc. So then they had a binding death benefit nomination in accumulation that then sent the money directly to the children. So it wasn't that they were necessarily at loggerheads, the 2 documents, but the reversionary pension documents for that pension only dealt with the pension side of things, whereas the binding death benefit nomination dealt with the accumulation account. They had a smaller amount in accumulation. And I think what we are seeing since the Better Simple Super stuff came in, we don't have necessarily as much money sitting in pension phase any longer. We actually have got more sitting in accumulation phase. So I like to have a very clear kind of concept around, well, if I have a pension and I want to direct my money to my spouse, and I want that to be automatic and I want that to be set, then that will sit under a reversionary pension. If I've got money sitting in accumulation, then that's either going to be dealt with under a death benefit nomination or a binding death benefit nomination, depending on the circumstances of the family. So I kind of like to box them.
Yeah.
And, try and keep them boxed in if I can, again, for that certainty reason, or as much certainty as I can have.
Yeah, well, that's certainly a good way to look at it. Now, this is a bit of a question for the ages, and you kind of semi-addressed it there, but is one better than the other? Because I can tell you, well, you well know in superannuation circles, there's this constant debate over whether or not you should have a BDBN over a reversionary pension. And it's almost like certain individuals believe that they are basically mutually exclusive. Is one really better than the other?
I don't actually think one is better than the other. I think they can both coexist. And I think you can have, like I'm saying, you can have your pension dealt with, reversionary pension documentation that gives you everything you want. You can have your accumulation account dealt with a binding death benefit nomination that gives you what you want, and they can both coexist and they can give you the full outcome of what you want. I don't necessarily think one is better than the other. I do have some concern about forcing a trustee to do something when that's not required. So I think that this blanket approach of you must have a reversionary pension and you must have a binding death benefit nomination, I think is short-sighted in some regard. For example, we've got a self-managed super fund, and it's the husband in the self-managed super fund. The wife died 10, 15 years ago. One of the daughters is divorced. and another of the daughters is starting a business, hypothetical situation. Business is on scratchy ground. Do we really want a binding death benefit nomination forcing money to both of those children? Maybe not. Maybe we don't. Because maybe we're just, handing the trustee in bankruptcy, potential trustee in bankruptcy, and the family courts, we're handing them this prize money of, several $1 million. Do we actually want that? Is it better for the trustee, whoever that will be at that point in time, the executor of the father's estate, would it not be better for them to make some decision at the lay of the land at that point in time?
Now, Trace, I should have probably clarified this at the start. When people refer to a BDBN, sometimes they use the terminology of SMSF will. Is that correct?
Yeah.
So, so just to alleviate any sort of confusion, when people talk about, oh, you must put in place an SMSF will, they are actually talking about a binding death benefit nomination. Why we can't be consistent on this stuff? I don't know. And there's no acronym for SMSF will either. So maybe that's not a terminology we like. But that is one and the same thing, isn't it, Tracey?
It is one and the same thing. And it goes a little bit further than that too, Darin, because an SMSF will, and I used to use that terminology, but I think it's confusing. So I don't use it as much any longer. That can actually be something that is hardwired into the trust deed as well. So, we've got this trust deed. We can actually hardwire or insert other clauses into the trust deed that are binding on the trustee as well. Because remember that trust deed, back to that conversation, the trust deed is part of the governing rules. So we can actually insert clauses and paragraphs that must remain and can't be changed. So there are things, so an SMSF will can be this document called a binding death benefit nomination, or it could go a little bit further and be hardwired or inserted into the trust deed itself. And there was, quite a school of thought for a while there, and maybe it's still there. I haven't followed it up recently around, a binding death benefit nomination document could be lost.
Yeah.
It's a separate piece of paper, whereas you've got the 60-page trust deed. It's going to be much more difficult to lose this 60-page trust deed than it is to lose a single page or a 2-page binding death benefit nomination. So if you hardwire your wishes into the trust deed, then maybe that's got more weight around it, or more certainty around it. I don't know about that. I don't know. If you've got minutes to say that you've accepted the binding death benefit nomination, the trustees accepted it from the member, et cetera, then you've got a lot of documents to lose, haven't you?
Well, it's literally more weight. It's one piece of paper versus a 60-page document. That's definitely more physical weight.
Yeah.
And I would actually also suggest that if your documentation or record keeping is so poor, you're just as likely to lose a 60-page document as you are a 1-page document if it's that tardy,
Yeah, exactly. And it might not come down to tardiness. It might be actually somebody doesn't want that binding death benefit nomination to exist in the first place. So, which is scary ground. So coming back to, I digress, but coming back to the question, an SMSF will and a binding death benefit nomination are effectively wanting the same thing. The reason I don't necessarily like the terminology around SMSF will is that we have to keep the message out there that your superannuation is not dealt with under your will. And so when we use the words SMSF will, people go, oh, I've actually got a will. I've done that. I don't need to do anything else. So I think it's really important to keep that message that, no, if you've done your will, fabulous, that's great. But your superannuation is not going to form part of the estate assets of the will unless you direct it that way, or unless the trustee sends it that way. So it doesn't happen automatically. So we need to have separate documentation in the SMSF space. Yeah.
Well, that's probably not a bad place to wrap it up today, Tracey. So again, we've run out of time, but thank you very much for joining me and putting this podcast together on what is a very important topic.
Absolutely. It's my pleasure, Darin. Thanks for having me again.
And of course, thank you to my team for putting together this podcast, but also for your company. And we hope you're enjoying these podcasts. We are obviously enjoying bringing them to you, and we will continue to bring them to you. We absolutely love it. We can talk about this stuff until the cows come home. We always run out of time. Don't forget, if you're enjoying our content on YouTube, please hit that like button and subscribe to the channel because that will really help us out. Other than that, thanks again, Tracey. And look, we look forward to you joining us again for the next episode of the Trusted Trustee podcast. Thanks again and have a great day.
Thanks, Darin.